What type of debt is not forgiven in a Chapter 7 bankruptcy? Attorney Michael McLaughlin explains.
Non-dischargeable debts are defined by the statute and include alimony and child support and domestic support obligations. Claims arising from fraudulent conduct are not dischargeable. For example, if a creditor alleges there was a misrepresentation of income on a credit card application or a pattern of usage on a credit card prior to the bankruptcy that could demonstrate the size and frequency of purchases with historical usage, then those debts might be non-dischargeable. In these instances, a creditor must file an adversary complaint and be able to prove fraudulent intent by the totality of the circumstances. Tax debts are generally non-dischargeable, but under some circumstances, they can be discharged if tax returns were timely filed and the debt is over 3 years old. Debts associated with an accident caused by willful conduct, such as drunk driving, are not dischargeable. There are other categories under the Bankruptcy Code that detail which debts would be unaffected. Matrimonial debts are an interesting category because they're considered domestic support obligations. Domestic support obligations include debts that arise as a result of a divorce decree or court order. Very often the issue comes up whether the equitable distribution component is dischargeable. In a Chapter 7 case, the rules are fairly simple in that if the equitable distribution claim was agreed upon in the property settlement agreement, then it's not dischargeable. In a Chapter 13 bankruptcy, equitable distribution claims are potentially non-dischargeable. This is determined on a case-by-case basis and requires a careful analysis of the nature of the debt and filing a complaint by the creditor. If the debtor's Chapter 13 plan devotes all disposable income and has been filed in good faith, a debtor may be able to partially discharge a matrimonial debt.
The law offices of Michael McLaughlin LLC is one of New Jersey's most experienced and respected in the field of bankruptcy representation. The firm acts for both debtors and creditors.